Good afternoon. For our last panel today, I get the privilege to introduce Judge Willett to you. I had the honor of appearing before him not too long ago, and he was very nice to me, so I said that I would do the same this afternoon. Don Willett is a judge on the United States Court of Appeals for the Fifth Circuit. He joined the court in 2017 after being nominated by President Trump. After a non-contentious hearing, he was confirmed by the Senate with a 50-47 vote. Judge Willett triple majored at Baylor before earning his JD with honors from Duke University. After clerking for Judge Jerry Williams on the Fifth Circuit, Judge Willett joined Habu's Austin office while also serving as a senior fellow at the TPPF. Judge Willett then served as Governor Bush's Director of Research and Special Projects before being appointed DAG for President Bush's Office of Legal Policy. Then Judge Willett returned to Texas to join then Attorney General Abbott as the Deputy Texas Attorney General for Legal Counsel. Governor Perry then appointed Judge Willett to the Texas Supreme Court in August of 2005. Of course, you all know how his Twitter presence increased in that role, being named by the Texas House of Representatives as the Tweeter Laureate of Texas. Judge Willett has become known for his plainly written and often colorful opinions. Those include his majority opinions, his dissents, and, of course, the occasional dubious concurrence. Without further ado, Judge Don Willett.
Thank you all for that mild smattering of applause. I appreciate it. John, thanks for the gracious introduction. Congrats on surviving the tyrannical Scott Keller regime in the SG's office. Hats off to you. Welcome, everybody, to the third and final panel, Religious Liberty and Conscience Rights in the Trump Era. Thank you all for sticking around. It is obvious that the dogma lives loudly within each of you. We have 4 all-star panelists in only about 90 minutes. So here's the plan. We're going to try to give about 15 minutes, give or take, to each panelist, which after my initial table setting and introductions of the panel, we'll leave roughly 20 minutes or so for speeches from the audience. Questions from the audience. Short, tweet length questions from the audience. Queries that actually end in a question mark from the audience. So I'm going to play things by ear. If a panelist wraps up before their allotted presentation time is over, then I may chime in. We may have some cross-panel discussion. And who knows, we might even have a Spartacus moment or two ourselves up here. So last May in the Rose Garden, on the National Day of Prayer, President Trump proclaimed, "As president, I will always protect religious liberty." And since he was inaugurated 600 days ago, just about, there have been many legal and policy developments touching on religious liberty. First, there was the president's sweeping religious liberty executive order in May of 17 to expand religious liberty protections, to expand those rights across the federal government. There was recently a new executive order creating the Faith and Opportunity Initiative within the White House. There's the Justice Department Religious Liberty Task Force and their own religious liberty guidance that sets forth about 20 litigation principles to guide their litigation strategy. There have been major policy changes within HHS, including the contraception mandate exemption, including other conscience protections and accommodations under the Affordable Care Act. There's been the creation within HHS of the Conscience and Religious Freedom Division, and we'll hear from one of our panelists about that today. There's even the USDA religious liberty guidance. There are DOD regulations new on military chaplains, and there are several other executive branch actions. But beyond the executive branch, There are a lot of judicial decisions in courts around the country, including, of course, in the U.S. Supreme Court. And of course, there's been the confirmation of roughly 70 or so far, Article 3 judges who will have their own say over the coming decades. Critics, and there are critics, and they say that all these reforms, all these appointments could legitimize discrimination, could harm civil rights protections, could hurt patient care. So the panelists today are going to touch on all these issues and more. Batting leadoff today will be Justin Butterfield, the Senior Advisor for Conscience and Religious Freedom at HHS. A native Texan, Justin graduated from UT El Paso, then attended Harvard Law School. Following law school, Justin worked in private practice, did some political campaign work in Texas, and then litigated alongside Kelly Shackelford some religious liberty cases for about 7 years at First Liberty. Justin has published widely, both scholarly pieces and in the popular press. But as far as I know, he's written no op-eds recently, anonymous or otherwise. Second, Eric Rassbach, the Vice President and Senior Counsel at Becket. Eric has litigated religious liberty cases at all levels of the state and federal judiciaries, including at the U.S. Supreme Court, where he has led or been part of litigation teams in each of Becket's blockbuster victories there, Hosanna Tabor, Hobby Lobby, and so on. He's represented people of almost every faith in America, as well as many governmental entities, represented them for accommodating religious rights. He publishes widely, he comments frequently on church-state issues in a slew of media and legal outlets. Before joining Becket, Eric worked at Baker Botts, a little mom-and-pop law firm you may have heard of. He also was a law clerk to federal judge Lee Rosenthal down in Houston. Native Texan, Eric speaks German fluently and a lot of other languages non-fluently, and he will go second today. Third, Kelly Shackelford. Kelly was recently named one of the 25 greatest Texas lawyers of the past quarter century. And for 21, I heard a wow in the crowd. For 21 years, which is about as long as we've known each other, Kelly has been the president and CEO of First Liberty Institute, the nation's largest law firm dedicated exclusively to protecting religious freedom, number one, in courtrooms, both state and federal from sea to shining sea, but also number two, in courts of public opinion. Under Kelly's leadership, First Liberty's legal team has won more than 90% of their cases. Graduate of Baylor Law School, Kelly is a constitutional scholar. He's argued before the U.S. Supreme Court, testified before Congress. Any protesters when you testified? No? He's won a number of landmark First Amendment and other religious liberty cases. He is a sought-after speaker. He is a familiar face on national news and talk shows. He is a frequent commenter in the national press, and he serves on the board of trustees for the United States Supreme Court Historical Society. And finally, batting cleanup today, Professor Nelson Tebbe, hands down the most degreed member of today's panel. Professor Tebbe is a graduate of Yale Law School and Brown University. He is also a Fulbright Scholar, and he holds a PhD in the academic study of religion from the University of Chicago Divinity School. As my mom used to say, he has more degrees than a thermometer. Professor Tebbe teaches con law, religious freedom, freedom of speech, legal theory. His scholarship focuses on con law and political theory, in particular, the relationship between religious traditions and democratic governments. And he is the co-author of a new casebook, Religious Liberty and Secular Government. He's written a whopping total of scholarly articles and opinion pieces galore. Before teaching, he clerked for Judge John Walker on the Second Circuit. He practiced law at the ACLU and at Davis Polk in New York. He is the author of a new book, which we'll hear more of today, titled Religious Freedom in an Egalitarian Age by Harvard University Press. And in that book, he examines this contemporary conflict between religious freedom and equality law. And he argues for a way forward that vigorously protects civil rights while safeguarding the ability of religious traditionalists to dissent from what they view as a new egalitarian orthodoxy. So Professor Tebbe will likely focus his remarks on his recent book, though he and the other panelists are obviously free to chime in with any additional ideas or comments. And with that table setting behind us, I'll turn to Justin. Justin, take it away.
Thank you, Judge Willett. So I'm a little bit restricted in what I can say because we're in the middle of the rulemaking process and litigation. But with that said, I'm going to be talking about what has been going on within the Department of Health and Human Services in the promotion of religious freedom. So as many of you are aware, religious freedom is the first freedom protected in the Bill of Rights, and it's a foundational right. But unfortunately, the history of the United States has not always lived up to that high standard that the founders established. In Madison's memorial and remonstrance against religious assessment, he said that the free exercise of religion is, in its nature, an inalienable right because it is the duty owed to one's creator and, quote, is precedent both in order of time and in degree of obligation to the claims of civil society. That is, Madison was saying that your religious freedom is more foundational than even duty to the government. He went on to note that if you don't have religious freedom, if the government does not respect your conscience and your religious beliefs, then it can tell you how you can vote. It can tell you, if you're on a jury, what you can decide on the jury. There is no aspect of your life that the government can't reach if it can reach your deepest religious beliefs. What led James Madison to that discussion? It was inspired most immediately by a bill that Patrick Henry introduced to institute a tax for pastors. But Madison was also coming to this from the context of a series of Baptist pastors that in 1774 Virginia had placed in jail for preaching as Baptist pastors, something that I think all of us today agree is illegal, right? Not enough laughter on that. In America, it's okay to be a Baptist pastor or a pastor of any other faith, just to set the baseline. But in 1774 in Virginia, that was not actually their baseline. And so James Madison wrote to his friend William Bradford, there are, at this time in the adjacent county, not less than 5 or 6 well-meaning men in close jail for publishing their religious sentiments, which in the main are very orthodox. I have neither patience to hear talk or think of anything relative to this matter, for I have squabbled and scolded, abused and ridiculed so long about it, to so little purpose that I am without common patience. So I leave you to pity me and pray for liberty of conscience to revive among us. And of course, as you all know, Madison's view won out. Following Madison's example of defending the rights of conscience and religious freedom, America has long respected religious freedom. We have laws protecting objectors from military service. We've had laws protecting law enforcement officials who don't want to be compelled to participate in executions that would violate their religious beliefs or their moral convictions. We have laws protecting people from being compelled to participate in abortions. In fact, the Supreme Court in 1965 in United States versus Seeger said, both morals and sound policy require that the state should not violate the conscience of the individual. All our history gives confirmation to the view that liberty of conscience has a moral and social value which makes it worthy of preservation at the hands of the state. So deep in its significance and vital indeed is it to the integrity of man's moral and spiritual nature that nothing short of the self-preservation of the state should warrant its violation. And it may well be questioned whether the state which preserves its life by a settled policy of violation of the conscience and the individual will, of the individual, will not in fact ultimately lose it by the process. So we value conscience and religious freedom in America. Following Roe versus Wade, the federal government, Congress, enacted a series of statutes to protect the conscience and religious beliefs of healthcare professionals who did not want to be compelled to participate in abortions against their will. Unfortunately now, though, that respect for conscience that has existed throughout the history of this country is coming under attack. And a lot of it is because so many Americans have a different worldview now. In 2007, only 16% of Americans said that they had no religious affiliation. By 2013, it was 23%, and among millennials, those born after 1980, it's between 34 and 36%. So a significant number of Americans no longer hold to a religious worldview, and so when they interact with people who are driven by a religious worldview, they don't understand that perspective. They don't understand what it means to be driven by something as core, as fundamental to their beliefs, as what they hold as their faith. And so we see situations like the nurse Kathy DiCarlo, a nurse in New York, who was told she would be charged with insubordination and abandoning her patient if she refused to assist with an abortion. Or we see Sandra Mendoza, a nurse in Illinois, who was fired for refusing to assist with an abortion. And on the broader scale, we see situations like Hobby Lobby and Little Sisters of the Poor that were forced through the Affordable Care Act's contraceptive mandate to provide insurance coverage for contraceptives that they believed they could not provide. They said that it would violate their conscience and their religious beliefs to be forced to provide that coverage. We've also seen many states and cities that are requiring pregnancy resource centers, organizations devoted to protecting life, forced to provide notices that provide information about abortions. And we've seen that most recently in the NIFLA case that was just decided. And those who don't understand the core place that religious beliefs take in believers' lives don't understand, well, why can't you just do it? Why can't you just provide the coverage? You can tell us you don't agree with it. You don't have to put your name on it, but why not just provide it? Because they don't understand how core, how fundamental to people's lives that is. Some of these situations, the federal government, and unfortunately HHS in particular, were the problem, either directly, such as with the Affordable Care Act contraceptive mandate, or indirectly through a lack of energy and enforcement of the conscience protection statutes that Congress has already given us. But this administration is committed to restoring the protections for conscience and religious freedom. In May of 2017, as Judge Willett mentioned, President Trump issued the executive order promoting free speech and religious liberty. And in Section 1 of that executive order, President Trump states, "It shall be the policy of the executive branch to vigorously enforce federal law's robust protections for religious freedom. The founders envisioned a nation in which religious voices and views were integral to a vibrant public square, and in which religious people and institutions were free to practice their faith without fear of discrimination or retaliation by the federal government. For that reason, the United States Constitution enshrines and protects the fundamental right to religious liberty as Americans' first freedom. Federal law protects the freedom of Americans and their organizations to exercise religion and participate fully in civic life without undue interference by the federal government. The executive branch will honor and enforce those protections." Following the executive order, the Attorney General issued a memorandum of October 6, 2017, titled "On Federal Law Protections for Religious Liberty," that basically explains 20 fundamental principles of religious liberty law for the agencies within the federal government. It basically took concepts from statutes such as the Religious Freedom Restoration Act, RLUIPA, the Religious Land Use and Institutionalized Persons Act, the Constitution, Title VII, as well as Supreme Court cases that have laid out what the Constitution and these laws mandate for religious protection. Cases such as Hosanna Tabor versus Hosanna Tabor Evangelical Lutheran Church and School versus EEOC, in which the Supreme Court recognized a ministerial exception to laws regulating who a church can hire as their pastor. Trinity Lutheran, the recent Supreme Court case where the Supreme Court said that you can't discriminate in the provision even of governmental benefits strictly on the basis of a religious character or affiliation. In that case, a church wanted to get ground up tires to use as a playground material, and they met all of the qualifications for the program, but because it was a church, they were skipped over, and the ground up tires were given to another playground. Supreme Court said you can't do that if your only distinction is this group is religious and this group is not religious. And then Church of the Lukumi Bablu Ai is a case actually on animal sacrifice, and it stands for the general principle that you can't have laws that, even though they look like they're neutral on their face, they look like they apply to everybody, but the underlying facts of the situation that led to those laws is a governmental targeting of religion. And we've seen this sort of statements that the government cannot be hostile to religion, most recently, as was mentioned earlier today, in the Masterpiece Cake Shops case, where the governmental hostility to religion was a significant factor that the Supreme Court looked at. So the Department of Health and Human Services has taken its approach to defending the rights of conscience and religious freedom. Last year, we issued interim final rules protecting religious beliefs and moral convictions with respect to the Affordable Care Act's contraceptive mandate. And then in January of this year, January of 18th, the Office for Civil Rights announced the establishment of the Conscience and Religious Freedom Division to restore enforcement of our nation's existing laws that protect our first freedom, and to encourage a culture within the Department of Health and Human Services that respects the rights of conscience and religious freedom. So the Office for Civil Rights within the Department of Health and Human Services has long had enforcement authority for certain federal conscience protections, such as the Weldon Amendment, the Coates-Snow Amendment, the Church Amendments. And that enforcement has been very weak historically. And when we have received complaints about it, we have found what I would call creative ways to get out of it. So for example, the Weldon Amendment states, none of the funds made available in this act may be made available to a federal agency or program or to a state or local government if such agency, program, or government subjects any institutional or individual healthcare entity to discrimination on the basis that the healthcare entity does not provide, pay for, provide coverage of, or refer for abortions. Now, when we received a complaint under the Weldon Amendment that a state government had discriminated against an entity for refusing to provide coverage of abortions, previously the Department of Health and Human Services Office for Civil Rights said, well, you don't really have a Weldon complaint here because you didn't meet the religious or moral convictions test under Weldon. You didn't state what your moral and religious conviction test was. Now, how many of you caught the religious and moral conviction test that you have to state under the Weldon Amendment? So again, it says none of the funds made available under this act can go to a federal agency or program or a state or local government if they discriminate against any institutional or individual healthcare entity. Well, you can't see it because it's in the invisible writing that you need the special bureaucratic goggles to read. And so only those of us who've been gifted these goggles can see that there's actually some other text there. No, the interesting thing about this is I've always thought of textualism as an area where the judiciary needs training. But since being at HHS, I've seen that bureaucrats need training in textualism too. Nowhere within the Weldon Amendment does it state that you have to state what your beliefs are before you can be protected for that. So we in the Conscience and Religious Freedom Division of the Department of Health and Human Services are working to make sure that these laws are enforced as Congress wrote them. And we're making sure that there is a vigorous enforcement, that these laws are not mere words on the paper, but that they actually have substance. Well, as you can imagine, when we keep issuing letter opinions that get rid of these complaints for things like the invisible clauses that aren't there, it discourages people from filing complaints with the Office for Civil Rights. In the 8 years before the 2016 election, the Office for Civil Rights received 10 total conscience complaints. Under that theory, there was just over one person per year whose rights of conscience were violated in an area under HHS's jurisdiction and protected by federal law. Since we've created the Conscience and Religious Freedom Division, as of yesterday, we've had about 165 unique complaints from the election to yesterday. So apparently there's quite a bit more than one person per year, or just over one person per year, who feels that their rights of conscience are violated. And we're working to make sure that where there is violations of federal conscience protection statutes, that those violations are dealt with. We are going to enforce the law. We created a new division so that it would create parity within the Office for Civil Rights with our other two divisions. One is the Civil Rights Division that handles other civil rights statutes, and the other is HIPAA. You may have heard of HIPAA. HIPAA gets blamed for everything. But so now with HIPAA and civil rights, we have Conscience and Religious Freedom Division. One of the, shortly after we created the division, we issued a notice of proposed rulemaking, which I can't talk much about because we're in the rulemaking process, and we've received 242,000 comments. So we are in the process of going through those comments.
How many comments?
242,000. So a weekend's work, right? No, it's been an extensive process going through those comments, and we're in the middle of that. But in the notice of proposed rulemaking, we proposed adding 22 additional statutory protections to the statutes that the Conscience and Religious Freedom Division can enforce. We also did something interesting to attempt to change the culture within the Department of Health and Human Services to be respectful of the rights of conscience and religious freedom. We got a delegation to enforce RFRA within HHS to the Conscience and Religious Freedom Division. And with that delegation, whenever HHS does something that might be violative of a person's religious freedom, we, as an internal office, can look at the statute and look at what HHS is trying to do, and we can say, okay, is there going to be a religious liberty problem here? Is what HHS is doing, does it comport with federal law and federalized requirements? So we're hoping that by doing that, we will ensure that the department as a whole is protective and respectful of religious liberty. And we are open for business. So you can help us if you become aware of a situation where a person's conscience or religious freedom are being violated. Go to our website at hhs.gov/OCR, and you can send us a complaint.
All right, Justin, thank you. Next up, Eric.
Thank you. I wanted to first say thank you to FedSoc for inviting me, and especially Matthew Kesmarek, who has just done a really awesome job with this. I go to a couple of other FedSoc state conventions, and this one is knocking it out of the park. I also wanted to say thank you to Judge Willett, and I had a little request, which is all is forgiven. Can you come back to Twitter? It's great to be back in Texas, as Judge Willett mentioned. I'm from Texas. I grew up in Houston and worked at Baker Botts in Houston after law school. You know, you sort of feel this warm, fuzzy feeling of just being around a lot of friends, and some that I haven't seen in years, so it's really great. I actually live in the San Francisco Bay Area, near Stanford, and so I don't always have the same warm, fuzzy feeling. So the topic is religious liberty and conscience in the Trump era, and I could talk about things like, you know, that Rose Garden ceremony that the judge mentioned. That was with our clients, the Little Sisters of the Poor. But actually, I want to talk about a different case that I think is, in some ways, kind of a little bit more of a parable about how religious liberty works out in the Trump era, and that is Harvest Family Church against FEMA, FEMA being Federal Emergency Management Agency. And just so I can set the background to this, this was a case that arose from Hurricane Harvey, which just about a year ago hit Rockport and then the Houston metropolitan area, and is to date, you know, the biggest hurricane disaster in American history. I, you know, was watching from California where it was very sunny, and I had, you know, family members who were like trying to figure out how do we get out of town, friends who are posting on Facebook pictures of their garage filling up. And I actually am from Meyerland, which is a neighborhood in Houston that was devastated by it. And the home I grew up in has been torn down now, my elementary school, everything. So it was a very personal kind of disaster for me. And, you know, I couldn't really do too much from California. But one thing that I did know was going to come up was that FEMA was going to tell houses of worship that they could not get any grants, disaster aid grants, because we had known about this for years. After Superstorm Sandy, a number of synagogues in New Jersey were devastated and could not get relief from FEMA. And that was because of some guidance, so this is the bureaucratic goggles or whatever, that arose during the Clinton administration. Nobody really seems to know why or wherefore, that said that houses of worship were categorically excluded from getting certain classes of disaster aid grants from FEMA. So we ended up, the hurricane hit on August 26th in Houston, and we actually filed suit on Labor Day, September 4th, right after that. One of the joys of electronic filing is you can do things on holidays. And so we filed this lawsuit in Houston Federal District Court, and we sought emergency relief. And here's the Trumpian, or one of the Trumpian parts of it, which is that shortly after we filed the lawsuit, President Trump tweeted about it. And as a lawyer, this kind of puts you in an interesting situation because he was sounding really positive about it. But of course, we also knew a lot about how the government works, and there is no, as someone was mentioning to me yesterday, unitary executive doesn't exist in practice at this point. And so we were pretty sure that that wasn't going to immediately translate into results. So we got into court the next day, and unfortunately, the judge thought it would instantaneously change the government's position, and he actually said, so, you know, we read this tweet with interest. I assume that the federal government will now be conceding this lawsuit or something along those lines. And I was like, oh no. And of course, they weren't going to concede anything because, you know, Department of Justice doesn't concede things. So we fought it out in district court. It kind of lingered for a long time in federal district court. We finally got actually denied a preliminary injunction. We filed an emergency appeal to the Fifth Circuit, which was denied as an emergency injunction, but was put on a very expedited schedule. However, it was still going to result in briefing in February, and I had clients who had rotting drywall that they had to figure out whether to yank out or not. And the catch-22 is that if you do any renovations to your sanctuary or building, any kind of building for a FEMA grant, without getting FEMA to sign off on it first, then you just don't get paid for that. So you have to get it pre-approved by your FEMA person, but they would not open accounts for my clients. So we sought emergency relief. That was turned down by the Fifth Circuit. So then in December of last year, we filed an emergency application to Justice Alito as the circuit justice for the Fifth Circuit. And he actually ended up requesting a response from the Solicitor General's office, which is not always the result of an emergency application to the Supreme Court. That changed FEMA's position. So they immediately announced that they were going to change their position and stop discriminating, basically based on everything that we'd said in our briefing about Trinity Lutheran case that Justin was mentioning, and just the idea that you need to treat, don't treat them better, but treat them equally. They actually sent something to the Federal Register, which they copied us on to prove, I guess, that they were in earnest about changing their thing, which is, please publish this as soon as possible because we have to respond to Justice Alito on January 10th in response to this lawsuit. And we also, by the way, filed a parallel lawsuit in Key West in the Southern District of Florida on behalf of a synagogue in Key West and another synagogue in South Florida that were devastated by Hurricane Irma shortly after Hurricane Harvey. So we had these two parallel lawsuits going. So they changed their position. They published new guidance. Now, this is still not a rule. And then Congress got involved. Congress said, let's implement this compromise that Republican and Democratic leadership had agreed to back in October as potentially solving this problem, but we'll only cover stuff like HVAC and structural damage, but we won't cover anything else. So only, sort of building stuff. And we and a lot of people wanted to just do that. And we said, that is grasping defeat from the jaws of victory. We just got them to change their policy, to change it to equality. Please do not go back on that. And eventually then Congress ended up adopting our viewpoint, and it got passed in February. And so now it's permanent, or I should say it's a statute, so it's as permanent as a statute is. So that was a pretty quick lawsuit for us. They don't always go that fast, but we filed in September and got a new law in February. So why did I want to talk about this? Well, I think that it's interesting because all along, the Department of Justice didn't defend these cases on the basis that they thought that the guidance was a good idea. And how could they, right? The administration's not going to want the Department of Justice to say, oh, sure, we should be treating houses of worship on a lesser ground. Instead, they pulled out the DOJ justiciability manual and started checking off the different things that they would say, okay, you don't really have this problem, it's not ripe yet, it's, all the usual sort of things that they do, and it's got to be taught the first day, at DOJ, that this is how you respond to every lawsuit. So, or at least lawsuits for me. So, and so they didn't have the courage of their convictions, but they didn't have the courage of their convictions in the other direction, which is that to actually argue for why they should have this, to actually get rid of it. And they could have just easily changed the policy in September instead of January. And this is what I want to get to about problems between religious liberty and the government generally, which is that I feel like these problems are structural problems in many regards. What's the first one? Inertia. Government has a huge amount of inertia. The federal government has a huge amount of inertia. And that inertia can be moving inertia, right? If you remember your high school physics, you have momentum. And one way to think about the federal government is that it's an elephant, a giant elephant, or maybe one of those elephants from the Lord of the Rings, with the 4 tusks or whatever, and it's moving along, and it doesn't matter who's on top. They can steer it a little bit this way or steer it a little bit that way, but if you're the guy fighting the elephant, even if your friend gets on top of that elephant, you better keep shooting at the elephant. And so we view inertia is such a problem that you've got to keep shooting at the elephant. Another thing about the structural problem here, if you think about the world of government as a sphere, and then you've got another sphere over here that's the world of religious activity, they intersect, right? So you have these sort of two spheres intersecting. And as the sphere of government expands, the intersection, that is the area where the conflict may occur, gets bigger and bigger. And so even if religion just stays in its same little place where it's been, doing education and healthcare and things like that since, almost time immemorial, the government starts getting in there and changing those things. And so that's one of the big problems. I mean, Justice Thomas was just talking about the administrative state. It's really it's a huge structural problem. It grows by itself like kudzu. It doesn't actually you actually have to fight it affirmatively in order to get it to stop. Third structural thing, the Klieg lights matter. So when you put government activity under Klieg lights, government actions change. Here, by Justice Alito just calling for a response to our emergency application, which, by the way, is a very hard standard to meet to get an emergency application. Suddenly, somebody told somebody, you know what, we gotta dump this policy as quickly as possible, and that was because when you get to the Supreme Court, the Klieg lights are pretty much always on. So that's another part. Fourth structural point. I view lawsuits as a method of education. We're actually helping governmental officials to understand what the stakes are of their decisions. Their decisions actually affect millions of people, and they're utterly unaware of it. They don't know. And it's not their business to know. No one's made it their business to know. So by filing a lawsuit, we help them to understand what the true stakes of what they're doing are. And I view it as giving people opportunities to do the right thing. So that's what we did. We sued FEMA. It wasn't necessarily that enjoyable for them, but they ended up doing something that I think is the right thing. So if you have a structural problem, what's the response to a structural problem? I say you have to have, it requires a structural and a strategic response. And it needs to be also a response that has a long-term view. You're not just thinking about, the next fight down the pike or something coming in 6 months or whatever. You're thinking long-term, and it's not personality dependent. You're not betting on people, you're betting on principles and trying to propagate those principles. And I think that's what we try to do at the Becket Fund. We think about things strategically, and we try to push forward that vision that we have. And we knew that FEMA had a problem, and we knew how it fit into the structure of American constitutional law. And so when this issue arose, we were ready to respond to it. So I think that's in the age of Trump, I guess I would say it's not really that different than in the age of Obama or the age of George W. Bush or the age of whatever, or I guess it's era. I don't know how we define eras, but it's the same. You're fighting, you're still shooting at an elephant.
All right, Eric, thank you. Eric says that litigation serves an educational purpose, and Mr. Shackelford here has been a litigation superintendent for a long time. So, Kelly, take it away.
Absolutely. I'm going to sort of lay out a number of things because I know we're going to have some discussion and time for questions. And so I was tasked with going over a number of things, cases that just happen, cases that are maybe about to happen, executive actions that happen, that just so everybody understands sort of where we are in religious liberty. So the first one, which although we heard about earlier that I was asked to talk about, was the Masterpiece cake shop case. And I think everybody knows the basics of that. You essentially have a baker who had two men that were going to get married, and it wasn't legal at the time to be married in Colorado, but they came and they asked for him to do their wedding cake. And he said he's happy to sell them birthday cakes, anything else, but he couldn't custom make a wedding cake because he would be participating in a wedding that violated his faith, and therefore he declined. That lawsuit, of course, made it all the way to the Supreme Court, and everybody was looking at what was kind of this huge sort of balance, right? On one side, you had these claims of free speech and the free exercise of religion, that essentially a baker was being asked to participate in an artistic expression of something he didn't believe, which is the free speech claim, and then you have the free exercise claim of this violating his faith. On the other side, you have the accommodation law, which a civil rights law, which tries to make sure that there's not discrimination people in places of public accommodation. And so, and in this case, obviously, is on the basis of sexual orientation. And so you had this conflict, and it seemed very difficult. How do you thread the needle because it's almost like if you go one way, it seems like the other way really gets smashed. And so the way Justice Kennedy dealt with it is he really doesn't answer the question on this specific types of cases. Instead, he took a middle ground in this case, somewhat based upon the facts of the case, where he said that in this case there was a lack of neutrality, in fact, a hostility to religion by the state of Colorado. Now, some people would say that's not significant because they didn't really answer the question. It certainly might delay. I mean, we have a case, for instance, out of Oregon that's almost exactly like this case. The bakers in that case were fined $135,000 for not doing the same-sex wedding cake. Their business is now bankrupted. They were actually ordered by the judge not to speak publicly their beliefs about this. So, I mean, that's not a First Amendment issue. But I think the fact that this case just happened might make it more difficult for them to want to take another one of these cases, yet they didn't really answer this type of scenario. What did they do? They said that in this case, I think there's sort of two, I mean, you could say there's a lot of things that happened, but the two big ones from Masterpiece to me are, number one, they answered a question or an argument that's been used a number of times to try to say that once you enter commerce, religious freedom doesn't protect you, or it doesn't protect you fully. The court completely rejected that argument in this case. This is obviously Masterpiece Cake Shop. And in particular, when they started their discussion of hostility to religion, the very first part of the discussion in the opinion was that just the argument that somehow by participating in the marketplace, their religious freedom was lessened was a sign of hostility. So I think that argument is over at this point, and those who wanted to say, well, the religious freedom goes away when you enter the marketplace. But secondly, they created a hostility to religion basis for winning the case as well. And what this reminds me of, there's a case called Wallace v. Jaffrey that's been around a long time, and this is a case about whether you can have a moment of silence. And this was out of Alabama, and essentially what the court said in that case is there's nothing really wrong with a moment of silence, but in this case they found some statements from the guy who sponsored it that said, yeah, we're pushing religion back in Alabama. And they said because of these statements, it showed that he was really trying to push religion and therefore it violated the Establishment Clause. And so since then, everybody in every case who deals in this arena is always like, if somebody's trying to pass some sort of law in the legislature, you got to be careful about what you say, because even if what they pass is completely constitutional, if they say the wrong thing, you can trigger it. Well, now this is sort of applying to the other side under the Free Exercise Clause. So even if somebody tries to pass something that might be not a violation of free exercise, if there's a hostility or this targeting, like under Lukumi that was mentioned, that's going to be a violation. I think that's one of the big issues that now is going to follow this case. Second, there were two cases. Sorry about that. There are two cases that were at the Supreme Court that were incredibly similar. One of them was Rowan County, North Carolina, the other Jackson County, Michigan, that involved, some of you might remember 4 years ago in the Town of Greece case, went all the way to the Supreme Court, can you have a chaplain open the meetings in prayer before a city council meeting? Supreme Court ruled, yes, you can. Goes back to the founding. It's kind of a Marsh v. Chambers type thing, and back to the founding of the country, and they upheld that. Well, these cases are very similar, except in both of these cases, the prayer before the county commission was led by one of the county commissioners. And so the argument, in one case by the ACLU and the other case by just a citizen, was, well, that you can't do that. Even though Town of Greece said you can have a chaplain, you can appoint a chaplain or have a chaplain say it, you can't yourself, as a government official, have a prayer. Both of these went en banc. And when they did, in one circuit, they said, oh, yes, this is a violation. I think that was 10-5 or 11-4 in the Fourth Circuit. In the other circuit, they said, no, this is not a violation. This has been in place since the founding. So I've never seen this before, but you literally had an en banc circuit split. And so most people thought, and Allison Ho was our lead, we were involved in both cases, and Allison Ho was our lead counsel in both cases, and thought, boy, this is highly likely to go to the Supreme Court. On the last day of the term, they rejected, they did not take these cases, to everybody's shock, and there was a dissent from denial by Justice Gorsuch and Justice Thomas saying, how can you not take this and resolve this issue? But they didn't. So that issue is now going to percolate all over the country, and we're going to see a number of these types of situations. The next one I would mention that is probably the most highlighted one that people think is maybe going to be taken soon, or could be certainly, is the American Legion case, otherwise known as the Bladensburg Veterans Memorial case. This is a veterans memorial that was actually put up almost 100 years ago. It was put up by the American Legion and in part by mothers who lost their sons in World War I to remember the 49 young men who died in World War I. And if you look at World War I memorials around the world, they're incredibly similar. They're the same structure. It's a cross of a certain type that they use to reflect sacrifice. And the lawsuit was filed by the American Humanist Association saying, you can't have this. This is Bladensburg, Maryland, right outside of D.C. And the Fourth Circuit, in a 2-to-1 decision, ruled that it was unconstitutional. They weren't very specific about what has to be done, but clearly you've got a bulldozer, you've got to move the memorial or tear it down or whatever if that stands. The more significant thing, I think that would create precedent that would create havoc all across the country with war memorials that have crosses or stars of David. I mean, it's prolific around the country. But even more so than that, the Fourth Circuit, where this decision was made, also within the Fourth Circuit is Arlington National Cemetery. And there are numerous large freestanding crosses that would, under this decision, would have to be moved or torn down or whatever. That is in the dissent from denial of en banc by the judges on the Fourth Circuit. This is and the lawyers on the case, our lead counsel is Mike Carvin, who many people know. Neil Katyal is also on the case. So we have some of the top litigators before the Supreme Court. So people think that this is a case to really watch. The next area that I was told to cover, and I'll do it quickly, is the area of the military cases. As mentioned earlier, there's been some DOD regulations for chaplains, but I'll just tell you, we are having serious issues with what's happening to chaplains in case after case. The most recent one is the Chaplain Squires case, and this is an example. You can see the kind of things that are going on. Chaplain Squires, a wonderful, wonderful person, was awarded the Bronze Star, Meritorious Service Award, I think 5 different times. And if you understand how things work in the Army, if you're a chaplain, you have to have an endorsing group, which is essentially a denomination that vouches for you, or you can't be a chaplain. And one of the requirements is that you have to follow the beliefs of your endorsing group, or you can no longer be a chaplain. Well, it probably wouldn't surprise you in the Southern Baptists that they're not allowed to counsel towards marriage or in marriage somebody who's not in a male-female, one woman, one man marriage relationship. But what they're told to do in regulations is if somebody approaches you about that in the Army, you find another chaplain that can do that, that doesn't have those religious restrictions. Well, that's what happened. 2 women approached Chaplain Squires. They said, we'd like to be a part of a marriage conference. And he said, oh, I'm really sorry, I can't do that because of my beliefs and my denomination, but let me find you a chaplain who can. He did find another chaplain who could do that, and you would think it would all go away, but no, a complaint was filed for discrimination. And the investigator, although realizing that he had followed all the regulations correctly, said, however, this violates discrimination. And not only did he find that against the chaplain, which has serious consequences to the career of anybody in the military, as you might imagine, even more so because the eventual finding was dereliction of duty, which means court-martial. We're talking about criminal. And the assistant chaplain who worked for him, a wonderful woman, African-American woman, who part of her service she had earned and was just about to start a free college tuition program. She was found in violation and her college tuition and everything taken away. And you say, well, what did she do? Well, she was the one that the couple came to first and said, can we see the chaplain? And she said, sure, let me connect you to him. That's what she did. And yet these 2 people were being really, I think, targeted because of their faith. The good news is after going through the process, we were able to get this reversed, but these are the types of things that are happening in the military to the chaplains. The other one I'll mention real quickly is the Rodriguez case. This is going to be ongoing because it's in federal district court or in D.C. Oscar Rodriguez If you've ever seen the flag folding ceremonies that are done, where they slowly unfold and fold the flag back during different military ceremonies, etc., Oscar has a speech he's developed that goes with that people really like, and that he's done it over 200 times around the country. Well, there was a man who was about to retire from the Air Force and said, "Oscar, would you do that at my ceremony?" He said, "I'd be honored to do that at your ceremony." And so on the base, he was having a private retirement ceremony, and as Oscar got up during the flag folding to say this, and by the way, it ends with, "God bless our flag, God bless our troops, God bless America." Unbeknownst to Oscar, the head colonel of the base had decided he didn't want anybody mentioning God on the base, even in a private retirement ceremony. And so as Oscar is standing up, and by the way, the wonderful thing for us as lawyers is this is somebody's retirement ceremony. There are video cameras. There's lots of tape of all of this. As he stands up, uniformed military grab him. And this guy's not in the military anymore. He's a United States citizen. Uniformed military grab him and throw him out of the room because he's about to mention God. Well, we went all the way through the system. Unfortunately, they refused to back down on this, so this is now filed. Both the airman who was retiring, who had his retirement ceremony ruined, and Oscar Rodriguez, both are plaintiffs. And this is in district court in Washington, D.C., and I think this will end up producing some very interesting law, and certainly on religious freedom in the military. Let's see, the last area is executive area, what's been happening. First thing I'd mention, I think we glossed over it quickly, but I think everybody is aware, as a result of the new administration, over 100 lawsuits by ministries that were having to deal with the Affordable Care Act and it trying to force them to violate their faith in different ways. Those lawsuits are all either settled or in the process of trying to be settled because of the different position of the administration. That's been significant. In a lot of these cases, and we represented a number of those ministries, but one of them, for instance, Chuck Swindoll's Insight for Living. Our case, we very quickly were able to settle and end after they changed their policy and said they weren't going to go after these ministries. The other thing, though, is we mentioned the executive order. I would just do a progression. You had essentially the president come in and issue an executive order on religious freedom throughout the federal agencies and government. Within that was a directive to the Attorney General to come up with guidelines. So the next thing you see is the Attorney General coming up with guidelines on religious freedom to help and be used throughout the federal government and agencies in ensuring religious freedom. And then you had more recently, the follow-up to that, I'm concerned, is the Religious Liberty Task Force, which is created within the DOJ, which had never been done before, to essentially make sure and help these agencies and also make sure that these things are being followed. Very unusual. Again, you've never seen that before, and I think it could have some significant results. Last thing I'll mention, because I want to make sure I'm under time. I see about 20 seconds, I think. Anyway, the last thing is judicial appointments. I think that's been significant. People like Gorsuch, when you look, I think he's probably written more opinions on religious freedom than anybody I'd ever seen nominated to the Supreme Court. So you could actually see his writings. And I think he's excellent on the issue. He's been good, whether he was writing a dissent or the majority decision. We felt like his analysis and his constitutional approach is excellent. I think Justice Kavanaugh, assuming that happens, is going to be excellent as well. He's got a number of opinions, and so I think there's a lot of things happening. My summary would be, we've never seen as many attacks as we're seeing around the country on religious freedom. At First Liberty, we had a record number. I think we had 420 legal matters last year, which is, we've never had that many. It seems to be growing every year. But the good news is I've never seen so many advances in different areas, whether it's cases or things happening with the government that seem to be moving in the right direction in protecting religious liberty. So overall, I'm very optimistic, although there's certainly more of a fight than I've seen before in the past.
Kelly, thanks. Professor Tebbe, you've got the anchor leg today, so tell us about your book and anything else you want to share with us.
Okay. Well, first of all, thanks for having me. I don't want to delay us unnecessarily, and I also want to hear questions from the audience, so I'll try to be brief. I want to thank the Texas chapter for inviting me here, and also to Judge Willett for moderating. It's really an honor to be here. I've been asked to speak briefly about my recent book, which is called Religious Freedom in an Egalitarian Age, and I'll try to do that, but also to just apply its lessons to some of the cases that have been discussed here today, including Masterpiece Cake Shop and maybe some others. The topic of the book is, as Judge Willett said, was this ongoing conflict between religious freedom and equality law. So this is not a full treatment of all the areas of law and religion, but instead a more targeted one. And it doesn't address questions like government displays of sectarian symbols like the Bladensburg Cross case, although I'm happy to talk about those. The book has 3 parts. First, it proposes a methodology for thinking through these questions, like how should we actually think about them? Second, it proposes 4 kind of mid-level principles that are drawn from the cases that I think can help us resolve these questions. And then third, it applies those principles and that method to concrete areas, right? Specific areas of dispute, and makes proposals in those areas. And so I'll just say a few words about each. You guys are probably least interested in methodological questions, so I'll be briefest here. But I did write a section about method because I was concerned that there were kind of skeptics or critics from both the right and the left of the political spectrum who were arguing, and I thought persuasively, which is why it was worth writing this section of the book, that there's really no reason-based way to resolve these conflicts. Like Masterpiece Cake Shop is so intractable that without a religious grounding to our government, we can't actually come up with solutions that are reason-based. And in the end, judges and other legal decision makers who are trying to wrestle with these cases just sort of choose a side, right? They sort of, if they're smart, they list kind of good reasons for coming down one way or the other, and then they just kind of choose. And I thought that was wrong, but powerful. And so I tried to come up with a way, I think I did persuasively come up with a way that we think about these things, which I call a coherence-based approach. So the idea is that what we do as citizens in our moral lives is not that different from what we do as legal practitioners. And that is, when we're dealing with a new situation that's difficult to resolve, we look for guidance to other cases that we've decided in the past or that our society has decided in the past, and that, after reflection, we think were correctly decided. And then we draw analogies to those cases. And if we can come up with a solution to the new case that kind of hangs together with the set of both concrete case resolutions, but also principles drawn from those cases that we think are correct from the past, then we can say that our resolution of the new case is grounded in reason. We've given a reason, right, for why we think the case should come out in one direction or another. This is not a partisan thing. I hope that it will appeal to people on both sides of the political spectrum. It's a plea for the sustained giving of reasons, even in areas of our law and society that are most sort of difficult to discuss across the aisle. I think this is similar to the common law method of judging and to the approach that political theorists like John Rawls have called the search for a reflective equilibrium. I think it's consistent with what Justice Thomas said about precedent in the discussion over lunch. That is, like, he's not sure that precedent should be followed in all kinds of cases. And it's also true under this approach that everything is revisable. We can look at past decisions and think like, oh my gosh, actually this new situation makes me think that we were wrong in the past. Like, it's all revisable. There's nothing foundational. But we have to come up with sort of really good reasons for overturning judgments that we've come to accept as a society. This is true in common law judging, but it's also true in our moral lives that we try to lead together as Americans. That's the first part. Second, principles. So using this method, I try to draw out from the real cases 4 principles that I think can help us resolve future conflicts. And these conflicts are coming, right? So there's already another lawsuit against Masterpiece Cake Shop, this time by a transgender person who wanted a cake that was pink on the inside and blue on the outside to celebrate her gender identity transition. The owner, Jack Phillips, the owner of Masterpiece Cake Shop, said no, and they're back in court, this time federal court. And I can imagine this case or some other case coming before the Supreme Court. So we're not done. We need to think about how we're going to resolve these cases. The first principle is avoiding harm to others. So in a series of cases, the Supreme Court has said that religious accommodations should not be granted where they entail harm to other private citizens. This rule is grounded both in the Establishment Clause and also in the Free Exercise Clause. Under the Establishment Clause, it limits statutory accommodations of religion, but under the Free Exercise Clause, it limits constitutional accommodations of religion. And the idea is that shifting burdens implicates the religious freedom rights of third parties themselves. Under this approach, though, not all burden shifting is prohibited. Only undue hardships raise constitutional difficulties. But we have lots of guidance from lower courts on how to administer that standard. So this is contentious. Actually, in one of the recent developments that previous speakers have highlighted, the Attorney General of the United States, Jeff Sessions, said there is no third-party harm doctrine. He singled that out as one of his sort of 20 points of guidance to the administration. I think that's wrong, and I also think the Supreme Court has said it's wrong, and I think it makes sense. I mean, this is an attractive kind of principle that I think will persist. Second, fairness to others. The idea here is that religious accommodations can't be granted where they would advantage believers over similarly situated secular citizens who wish to engage in the relevant activity for deep and profound reasons of their own. Here, the canonical example is conscious objection to the draft. The Supreme Court has said that cannot be limited to religious believers the way Congress tried to, but has to include all sincere, profound objections to war in all forms. Here, I think we've seen bipartisan advances. So the notice of proposed rulemaking, or maybe it's the interim final rules. I think it's the interim final rules that Justin Butterfield mentioned on the contraception mandate, don't just relieve religious actors from the obligation to conform to the contraceptive mandate, but also people who oppose the contraceptive mandate on what the administration calls moral grounds, right? So I think we're seeing some movement in the direction of recognizing that there's a rule of fairness to others. Third, freedom of associations. This is very important. Community organizations, civic organizations play a crucial role in a democracy in forming citizens' wills and worldviews, and they must enjoy a constitutional guarantee that they can continue to do that even in illiberal ways that would otherwise violate civil rights laws. I set out an understanding of how this works in the book. I do think it's very important. And it's a place where the rule of avoiding harms to others doesn't apply, right? So these organizations get to decide who's a member of their group, and in certain circumstances, who leads their group, even if that would entail harm to others. And I think that's just a feature and not a problem of our constitutional law in this area. And finally, government non-endorsement. Through its support, either expressive or material, the government can take sides on questions that bear on citizens' freedoms and identities. And on this principle, the government may not use its expressive or material support to harm the full and equal citizenship of all members of society. That's why the Establishment Clause prohibits a town from declaring, this is a Christian town. But I don't think that religion is special here. The Constitution also prohibits a town from saying this town is for whites and other kinds of statements that would have exclusionary effects. I think government endorsement, this principle, captures that aspect of democratic morality. The tricky question is, of course, where the line should be drawn, but that's a question of implementation. So on implementation, in the third part of the book, I make recommendations in 4 areas that strike me as most likely to be the most prominent sites of conflict between religious freedom and equality law going forward. The first is public accommodations law. So this is Masterpiece Cake Shop, right, where religious actors are participating in the marketplace, and public accommodations laws protects customers from discrimination in that marketplace. The second area is employment law. Recently, for example, the Sixth Circuit decided a case concerning a transgender employee who was fired from her job at a funeral home for violating the dress code. The court rejected a RFRA defense in the Sixth Circuit. That case is now on certiorari to the Supreme Court, and we'll see whether they take it. My point here is just that employment law is going to be an area where we're going to see repeated conflicts here as well. Third, public employees. The big case a couple of years ago was Kim Davis, who was a county clerk in Kentucky who refused to process LGBT weddings after the Obergefell case came down, or actually in the lead up to the Obergefell case. or there were judges in North Carolina who sought to recuse themselves from presiding over such ceremonies. This is going to be an issue. I actually don't think that liberals are right here. I think that it's possible for some accommodation of these public employees to be allowed, and I think that because I was analogizing to situations where the political polarities are reversed, like the death penalty, and where in fact we do allow public employees some leeway as long as to recuse themselves as long as the interests of third parties are protected. And then finally, public funding and support. May a town withhold funding to private organizations that hold traditional views on matters of sexuality or religious freedom? We've seen a recent case in Philadelphia where the city denied funding to religious adoption agencies for this reason. How should we deal with those kinds of cases? We can talk about what my recommendations are in each of those if you want, but here I'd like to just focus for a minute on the Masterpiece Cake Shop decision, which is kind of run through the comments on today's panels, and what it might mean for the future. Many people, liberals in particular, but I think conservatives as well, have described the opinion by Justice Kennedy in this case as narrow. Liberals think it's narrow but mistaken, conservatives think it's narrow but correct. I actually agree with Aaron Street from the first panel that the case is not narrow, that it's narrow in its result, but that there are principles that were pronounced by the court that are correct and quite helpful in resolving future disputes. I think he's right that the court said quite clearly that religious people who are acting in the marketplace deserve our respect and the respect of the government, and that their views are not reducible to bigotry. I think that's correct. I think the Supreme Court said that, and I think it's right as a matter of principle. I also think it's correct to say, as Kelly Shackelford said just a minute ago, that the court said, you don't surrender your religious convictions merely because you enter the marketplace. And that seems to me right, and also something that the court did kind of affirm in its opinion. But it affirmed other things too, and I think these principles ought to be taken into account in the future as well. First, expressive harm counts. So when thinking about third-party harms, and Masterpiece Cake Shop is a third-party harms case, because if Jack Phillips, the provider of the cakes, were exempted from civil rights laws in this case on the basis of religious freedom, that would entail harm to other citizens, namely the same-sex couple that came to him for a wedding cake and people similarly situated. People have responded to that argument by saying, well, they were easily able to get a cake down the street, so that there was no economic harm to them aside from trivial search costs. But the Supreme Court in the Masterpiece Cake Shop decision said quite clearly that there was an expressive harm to them that matters in civil rights cases. There's some, and the Supreme Court, because I think it was influenced by Justice Kennedy here, phrased this in terms of dignitary interests. That's not my favorite phrasing, but the idea is that non-economic harm matters in these kinds of cases. Second, harm to third parties matters, right? So there's some debate among academics. I mentioned Attorney General Sessions' opinion in this regard about whether harm to third parties has any legal significance at all, or whether there is a rule against harm to third parties. An alternative paradigm here has been conscience protection in the area of reproductive health, where conscience clauses typically are insensitive to the effects on women seeking medical services. The court did not follow that paradigm here and said instead in the Masterpiece decision that the anti-discrimination model is appropriate and that harm to third parties does matter under that model. And then finally, the court reaffirmed that normally religious actors don't enjoy exemptions from civil rights laws that apply in the same way to everyone under the Constitution. The Religious Freedom Restoration Act was not at issue in Masterpiece Cake Shop because it was a state law, and the state of Colorado has no state-level RFRA. So the rule in place was the normal rule under the Free Exercise Clause, which is that a general law does not admit for religious exemptions. And the Supreme Court said normally that is the rule, and cited a case called Piggy Park from the Civil Rights era for that proposition. Not only did the majority embrace these propositions, and it was a 7-justice majority, but arguably every member of the court did, because I think we can assume that the dissenters would would agree to them as well. Now, there are some complications here. Aaron Street in the first panel mentioned these. Larry Sager and I have written a piece that tries to address them. In particular, there's some debate about between the concurrence by Justice Gorsuch, joined by Justice Alito on the one hand, and the concurrence by Justice Kagan, joined by Justice Breyer on the other hand, about how far these kinds of principles go. And we can talk about that during the discussion if you want. I think Aaron Street is right to say that Justice Gorsuch, in his opinion, suggested that there was kind of a structural problem, that if Colorado protects bakers who refuse to provide wedding cakes that carry discriminatory messages accompanied by religious quotations or citations to scripture, but then doesn't protect Jack Phillips, that there's a kind of structural problem there, that the civil rights law in Colorado is viewpoint discriminatory or otherwise unconstitutional. Justice Kagan had a different view on that question. I think neither of them is particularly satisfactory. But overall, I think Masterpiece Cake Shop was broader than it's typically been perceived, and kind of aligns with at least some of the core principles that I've tried to advocate for or identify in the book, and good news for the development of American constitutional law more generally. But I'll be interested in your views.
Professor, thanks very much, and to all of our panel. I've got one question, and Professor Tebbe mentioned, how it wasn't really kind of teed up or front and center in Masterpiece, and that kind of triggered a question in my noggin. So a lot of you are too young to remember, but federal RFRA was enacted 25 years ago, 1993, landmark piece of legislation with the most improbable, thank you, the most improbable, can you hear me okay? Range of supporters that has probably ever been sort of gathered behind any major legislation, yet everybody on the far right, everybody on the far left, and everybody in between kind of linked arms, united behind this bedrock commitment to religious liberty. It passed the House unanimously in 1993. I think there were 3 nay votes in the Senate. The Texas RFRA, and I think 21 states now have a RFRA across the country. Texas has one. It's coming up on its 20th anniversary. Kelly and I were both involved in drafting and shaping that. Actually, Jim Ho argued the very first Texas RFRA case brought in the Texas Supreme Court several years ago. That too really boasted this improbable, strange bedfellows coalition. And I just say all that to ask this. We've heard a lot today about litigation that's kind of making its way through courts around the country. We've talked a lot about what's happening at DOJ and HHS and DOD and elsewhere. What is happening in Article 1? Where's the lawmaking branch when it comes to this? And I'll just kind of tee that up for anybody who wants to respond, and then we'll hear from the audience.
Well, isn't the lawmaking branch pretty involved? I mean, Eric Rassbach just told a story about how Congress fixed a problem, right?
Yeah, there's kind of the rifle shot FEMA sanctuary example, but certainly nothing remotely on a RFRA-type scale.
Well, RFRA was a big piece of legislation.
Sure.
A lot of people on the left are sort of opposed to religious exemptions altogether, and therefore opposed to the idea of RFRA. And I'm not one of those. I think that religious exemptions are important. I wish the constitutional rule provided for them under the Free Exercise Clause. But I'm glad that RFRA exists because sometimes you really need that kind of protection for not just religious equality, but for religious liberty, or for the ability of people to practice their faith, even though general laws get in the way. A recent example is Holt v. Hobbs, right, where a prisoner in a state prison wanted to grow a half-inch beard for religious reasons. He was a Muslim. And the prison said no, but didn't really have a good reason for why he couldn't, right? There weren't any real security problems here. he used a different federal statute that's kind of a cognative RFRA called the Religious Liberty Institutionalized Persons Act, and won bipartisan victory in the Supreme Court. If we didn't have a religious exemptions kind of regime, he would have lost, and that would have been a great injustice in my view. So I'm a supporter. But the reason that it's become sort of polarized is because there's a long history between 1993 and today. And I think the main thing that happened was the advent of the LGBT rights movement, right? So once same-sex marriage became a kind of national issue after Hawaii courts started to decide that there was a right to same-sex marriage in the mid-90s, the coalition that had supported RFRA kind of fell apart. And it became a lot harder to pass those kinds of laws, and that characterizes the split today, right, that I just sort of described.
I was given this note, very understated. It says, stop at 4:15. So we've got 5 minutes if anyone wants to hop up and ask an impertinent question. Yes, sir.
There you go.
Chuck. Thanks so much for doing this panel, and all of y'all are seeing the litigation with RFRA. Know that it's a battlefield, so you grab whatever tool you can use and whatever exists. Here's my question. Given that all these cases, or a lot of them, are coming down 5-4, and Professor Tebbe, you talked about thinking of something new. If you're a transcendent person, you believe there's a higher power that controls you, doesn't the fact that the RFRA standard that we're eking out victories on for people who believe in transcendence, doesn't the fact that came out of the postmodern Warren Court, which really doesn't acknowledge a transcendent value, the values are sold to the individual, doesn't that create a problem with a real shaky, potentially devastating consequence, and it's solely based on the judge?
And Professor, if you could try to be brief, and we'll try to get these others in.
Okay,
the next
I'll
3
try to
minutes.
be really brief. I see that concern, but a lot of these cases are not decided 5-4. Masterpiece Cake Shop was not 5-4. Trinity Lutheran was not 5-4. What else? Hosanna Tabor, the ministerial exemptions case, that was unanimous against the view that I'm proposing, right? So like, Holt v. Hobbs, not 5-4, right? These are, I'm not sure I see the world that you're describing. I also don't see the world where religious liberty is sort of tremendously threatened. Religious interest prevailed in all of these cases: Trinity Lutheran, Town of Greece, Hobby Lobby, Masterpiece Cake Shop, Hawaii v. Trump, maybe not Hawaii v. Trump, Zubik, arguably, Holt v. Hobbs. I mean, religious interests haven't lost a case in the United States Supreme Court in like a long time, with the big exception of Obergefell.
Okay, these 2 questions and we're done.
Professor Tebbe, I'm Jordan Lawrence. I worked on the Masterpiece case for ADF, and I wonder what you think about Clarence Thomas's concurrence on the free speech, compelled speech claim, and that many of the principles you laid out seem to be addressed if this was dealt with, and the court avoided this, as a compelled speech. Dignitary harm, I'm thinking of the Boston St. Patrick's Day parade case. It was obvious the rejection inflicted dignitary harm on the gay group, but they said, but this is compelled speech, and the punishment or the solution is worse than the third-party harm here. And that seemed like that would have resolved this case on a more clear basis than the free exercise claim. Or at least, I just wanted to see what you thought of what Clarence Thomas said. He seemed to be the only justice that addressed that.
You're Jordan Lawrence?
Right.
Oh, yeah.
Yes.
We debated each other at a
Yes,
Federalist
in
Society event in
Brooklyn.
New York
Yes,
about Bronx
on the
Bronx
Household
Faith.
of Faith. Yes.
Yeah.
It's been a long time. Good to see you.
He's being modest. He's one of the most prominent litigators in this area, like in the country. Nice to see you. I think the compelled speech argument is interesting. I mean, the Supreme Court struggled with it greatly during oral argument, right, in the Masterpiece Cake Shop case. My own view is that it can be decided this way, right? So it is true that a vendor, right, or a provider of services who's subject to public accommodations laws can decide to reject someone because of the statement that that person is asking them to make, right? So in the companion case, or the sort of juxtaposed cases in Mashpee's Cake Shop, William Jack asked 3 different bakers to bake cakes that bore kind of anti-same-sex marriage messages and were accompanied by quotes to religious scripture. And those bakers said, no, we're not gonna bake those cakes. That seems to me to be appropriate, right? So Colorado said, we're not gonna prosecute that, and I think the reason is because it would amount to compelled speech, right? But what providers can't do is reject people because of their identities, right? Because of what they're doing. In Mashpee's Cake Shop itself, there was no discussion about what kind of cake they would have, right? Even before they got to that stage, Jack Phillips said, I'm sorry, like you want this wedding cake for a same-sex ceremony, and that's not something I can do under my sincerely held religious beliefs. So that doesn't seem to me to be a compelled speech situation. So that's where I would draw the line. I think there are cases cutting the other way politically where I think it's totally fine for conservative providers of like T-shirts to say we're not going to provide T-shirts that celebrate gay pride, right? Because that's saying I don't want to be involved in propagating a particular message. It's not an identity-based exclusion. So that's how I would draw the distinction.
And the final question of the entire conference.
All right. So I guess it's the counterpart to Judge Willett's question is I would ask where are the courts on these issues? And Kelly, you kind of emphasized that in the Lund and the City of Jackson cases. In those cases, I think 30 some odd states came together to file briefs and talk about how prominent this issue was, that hundreds of counties around the nation have commissioners or whatever that are leading prayer before sessions. And it being such a clear circuit split, seems odd that they wouldn't take the case. It also seems odd that a pattern might be developing of the court being unwilling to answer these questions, or at least not ready. They avoided the question in the Trump v. Hawaii case in the Establishment Clause, and even though the professor said that the whatever case we were just talking about was more broad than is given credit to the masterpiece, right? It seems like they did the best they could to make that as narrow as a holding as possible. So I guess my question is, can you speculate as to the court's readiness to answer these sort of questions, and where do you see that going forward, especially with these big cases in the pipeline?
Well, I think the common thread to what you ask, for instance, I mean, the theory given as to why a number of these things are happening, like why wouldn't they take some of these cases? Why did they? A number of people saw sort of a clearing of the deck right at the end because Kennedy was leaving and somebody else was being brought in, and maybe they didn't want to politicize any more than necessary the nominations process. If there were these big cases waiting, then, I mean, the way the nomination, the confirmation process was already becoming a circus might have been even, that just adds a little more fuel to the fire. So some of the theory is that a number of these cases weren't taken because they didn't want to add anything else into the hopper that could be lit on fire during, Kavanaugh's hearing. Who knows? What would that mean when he comes in? They're going to start slow too? I don't know. I don't think it says anything about, what's going to happen with religious freedom. I just think that might be the case of being safe and just kind of slowing things down until they get the new justice. I do feel good about where things will go with Justice Kavanaugh coming onto the court. He's a person who cares about religious freedom. He donated his time as a young lawyer in a number of cases, Jewish synagogue and some other cases, in a case that I was working on, and I think his writings have been excellent on religious freedom. So I feel really good about where he's going to, what he's going to add to the court, and he's very thoughtful. But we'll have to wait and see what happens in the future. I think people don't realize the battle we're in. There are a lot more of these struggles than, I've been doing this for 29 years, and 29 years ago, this kind of stuff wasn't happening on religious freedom. We're in the center of really battling over this and where we will go in the future as a country, and I don't know how long that's going to take to figure out, but we're certainly in the middle of it.
And it's only fitting that Kelly Shackelford gets the last word on all this stuff. So thanks, everybody. We're done.